Hello, welcome once again to Lehto's Law. I'm Steve Lehto. Today we're going to talk about jury nullification. Jury nullification. This is something I've been asked about quite a few times, maybe one of the most requested topics that I've avoided doing for a little while. And we'll talk about it today. In case you don't know what jury nullification is, it's the concept that, if you go to trial and a jury is hearing your case, if the prosecution convinces them beyond a reasonable doubt that unanimously they all find beyond a reasonable doubt that you did it, they find you guilty. Of course, if all of them find that the prosecution failed in its burden of proof, they then find you not guilty. And what many people don't know, except people in the legal community and some other little areas we'll talk about, is that juries often get together and say, the guy might be guilty, or the gal might be guilty, but there's something wrong with the law, or there's some other reason that we don't think a conviction is appropriate. And then the question becomes, what happens if the jury decides to disregard its instructions and simply find somebody not guilty? And that idea is jury nullification. And it goes back quite a ways in our jurisprudential history. Wow, can't believe I said that correctly. And goes back to, pretty much ever since there have been juries. And I believe the Magna Carta was one of the first documents that described juries. I could be wrong on that. But juries came into use in, Britain a long time ago. And then, of course, when we brought the legal system and the common law to America, we brought along with the jury system. And again, juries were hearing cases in the colonies. And then when we became the United States, we were hearing cases as well with juries. And juries are preserved in the Constitution, for instance. And so juries are a major part of trials in America, civil cases and criminal cases. But we're talking about criminal juries for the most part here. So the notion that a jury can do whatever it wants during deliberations is something that we understand as a possibility. But the question is, are they doing something wrong by doing this? And the question, which is even scarier, is it wrong to be discussing it? And I'm not kidding. And so, just to be clear here, I am not advocating for jury nullification. And the reason I'm not advocating for it is that they've arrested people in Michigan for talking about it. So, a man named Keith Wood in Big Rapids, Michigan, which is someplace up here, was outside the Mecosta County Courthouse north of Grand Rapids in 2015 distributing pamphlets that described the concept of jury nullification. And it was a pamphlet he got from some organization. He's just handing it out on the sidewalk in front of the courthouse on a day that court was in session. Now, there were no trials being heard that day, but apparently they were thinking of selecting a jury for a case, but the jury never got selected. So there was no jury to, be doing something in that courthouse that day. And so while he was handing these pamphlets out, a few people walked into the courthouse with him, and somebody saw someone sitting in the hallway reading a pamphlet about jury nullification. And eventually, a judge asked somebody to go fetch that man, and they brought him into court, and they actually held him in contempt of court. So think about this. You're standing on the sidewalk, public place, sidewalk, in front of a courthouse, and a judge has you hauled in and held in contempt of court. And then he was prosecuted and convicted by a jury. This is like a Twilight Zone episode. So he took that up on appeal, and the Court of Appeals twice heard issues arising from his case, and they actually ruled late in 2018 that his misdemeanor conviction was going to stand. So the conviction stays in place. The judges who wrote for the opinion said, "We cannot overemphasize the importance of the jury's finding that Wood intended to influence two jurors summoned for Yoder's case." Yoder was the guy on trial that day who may have had a trial. "It is that specific level of intent that takes defendant's case out of the general pamphleting activities protected by the First Amendment." And they claim that the state has a compelling interest in protecting the sanctity of the jury. Therefore, this guy shouldn't be handing out pamphlets explaining to them what their rights are. In a dissent, Judge William Murphy said he would have overturned Wood's conviction because the two people that it was confirmed who got these pamphlets didn't become jurors. So how do you tamper with a non-existent jury? But here's the problem. And I've been an attorney for 27 years now. This year it'll be 28 later on. And jury nullification is something I remember reading about it before I went to law school. I remember when I was thinking about going to law school, I remember reading articles. Anytime stuff popped up in the papers about the law and so on, I remember reading articles about jury nullification back in the 1980s. And like I said, they've been discussing this for a long time. And basically, the rule is this: the juries can do this, but they're not supposed to do it. And under no circumstances is an attorney allowed to tell a jury they can do it. That's the strange part about this. So again, I'm not advocating jury nullification. I'm simply describing it to you. So in the case of Keith Wood, he actually got arrested and convicted of tampering with a jury because he was handing out pamphlets that described jury nullification, because he was doing it apparently within eyesight of the courthouse. But I'm talking about Michigan now, just to give you an example. Under Michigan law, juries have the power to dispense mercy by returning verdicts less than warranted by the evidence. And that's according to a Michigan Court of Appeals case. So they can do this. They can do this. But the Michigan Supreme Court also has said that the jury has the power to disregard the trial court's instructions. It does not have the right to do so. Follow that? They have the power to do it, but not the right to do it. And what they're basically getting at is, when a jury deliberates, they go behind closed doors. The 12 jurors, or, it could be a misdemeanor case with fewer, but the jurors in the jury room deliberate amongst themselves. And no one is allowed to interfere, eavesdrop, communicate with them about what they're doing. And once they come out, all they do is they render a verdict. They render a verdict. And the only thing that you are allowed to ask a juror after they have rendered a verdict is that and was that your verdict? And so you'll often see in a trial where a jury comes out and they've rendered a verdict, and someone will say, "Excuse me, Your Honor, may we poll the jury?" And the jury will then be polled and asked, "Is that and was that your verdict?" Because they want to make sure that, in fact, there's 12 jurors, or make sure all 12 of them agree. And I've never seen a situation where one juror said, "No, that wasn't my verdict," but it's possible it could happen. But the point is that you don't say, "By the way, how'd you reach that verdict?" Now, we've all seen the TV shows, and I can tell you right now, as an attorney, when a trial is over, I've had a judge tell the jury, "If you want to stick around and talk to the attorneys, you can, but you don't have to." And attorneys know that many jurors are so sick of jury duty, they want to get out of there and go home. But I've had jurors who sat around and stayed and said, "Yeah, you want to talk about, and I've asked them, did you believe my guy? Did you believe their guy? What did you like? What didn't you like?" And you just get some feedback. And it's an interesting learning experience to deconstruct that after the fact. But you don't ask them, "Why'd you get that? Where'd that verdict come from? What's wrong with you?" And so, that's kind of what's going on here, is that the jurors can do whatever they want behind closed doors. And once they've come out and rendered their verdict is rendered. And you don't have a right to go back and ask what they did back there. Now, I know that some of you have probably heard of cases, though, where a juror did something inappropriate and word got out about it, and somebody did investigate. And there are circumstances with juror misconduct where, for instance, let's suppose you have a case that involves the way a gun operates, okay? And, the gun is part of the story. It gets into evidence. A couple experts get up and talk about it. And one of the jurors says, "You know something? I've got a gun like that at home. I'm going to go home and see if I can get my gun to do that." So the juror goes home, experiments with his own gun, comes into court the next day during the second day of deliberations and says, "By the way, guys, I ran some experiments at home. Here's what I discovered." They're not allowed to do that. And if it came out that happened, that could cause problems. But what happens in America is, if someone gets convicted, you can appeal the conviction or you can examine all kinds of stuff. But if they get acquitted due to double jeopardy, you can't retry them. So obviously, if somebody gets acquitted and you found out later that there was some jury misconduct, you can't retry the person. So it's over. So occasionally it's with the convictions you hear about, where somebody figures out, "Hey, wait, the jury did something inappropriate." I've heard a few examples, but I don't want to get into that right now. But the point is that the jurors are put behind closed doors. They come up with a verdict. It's unanimous. They come out. They render their verdict. If they can't come up with a verdict, then they announce they're deadlocked. Whole process there. But here's the point. Occasionally, things happen that hit the news. And this is an unusual case, but I remember reading about this at the time. But a woman named Laura Creho out of Colorado was seated on a jury, and apparently, during jury deliberations, she talked to the jurors about the fact that if you guys want to, we can find this guy not guilty, not because he didn't do it, but because we just disagree with the law, jury nullification. And she apparently used those words. And so when the judge found out about that, he actually had her prosecuted, and he prosecuted her on the theory that during jury selection, she hadn't disclosed at one point in time she was accused of a drug crime, but she was not convicted. And when asked, have you been convicted of a drug crime, she said no, which was a truthful answer. And they prosecuted her on the theory that that was not truthful because she left out the fact that, well, I've been arrested for one, but not found guilty. She was convicted, but on appeal, the appeal was thrown out. And that all happened in Colorado. So it's kind of a strange concept that a juror could be charged with, in essence, a crime. And it looks like one of the large factors that went into it was the fact that she mentioned jury nullification to the other jurors in the jury with her. So here's the thing. Again, I'm not advocating jury nullification. But in Michigan, if you look at the jury instructions, and I have them right here, for instance, the jury instruction that talks about the burden of proof. It says a person accused of a crime is presumed to be innocent. And these are the instructions read to the jury, explaining to them what the law is. This means that you must start with a presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he or she is guilty. Okay? So that talks about what kind of verdict they're entitled to. Once the jury is selected and sworn, they are sworn to an oath. Here is your oath. Each of you do solemnly swear or affirm that in this action now before the court, you will justly decide the questions submitted to you, that unless you are discharged by the court from further deliberation, you will render a true verdict. A true verdict. And that you will render your verdict only on the evidence introduced and in accordance with the instructions of the court, so help you God. You will render a true verdict. Question is, what does that mean? 2.3, trial procedure, and it describes the process of the trial through various steps. And at number 6, it says, after all the evidence has been presented, the prosecutor and the defendant's lawyer will make their closing arguments. Like the opening statements, these are not evidence. They are only meant to help you understand the evidence and the way each side sees the case. You must base your verdict only on the evidence. See, what I'm doing here is I'm picking out all the sections of the jury instructions that tell the jury what they are supposed to do once they've gone back and deliberated. So when they're about to go back and deliberate, they're told, remember that you've taken an oath to return a true and just verdict. A true and just verdict. As jurors, you must decide what the facts of this case are. And that's always true. The jury decides the facts. The judge works on the law. And then another one says, it is my duty to instruct you on the law. You must take the law as I give it to you. So they do say, here's the law. You must follow the law. But then, to sum up, it is your job to decide what the facts of the case are, to apply the law as I give it to you, and in that way to decide the case. Again, rendering a true and just verdict. Now, I grabbed an example of the thing where you described the charges, and I picked one for reckless driving, because I've actually tried a reckless driving case with a jury. The defendant is charged with a crime of reckless driving. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, the defendant drove a motor vehicle on a highway or other place open to the public, and that the defendant drove the motor vehicle in willful or wanton disregard for the safety of persons or property. Willful or wanton disregard means more than simple carelessness, but does not require proof of an intent to cause harm. It means knowingly disregarding the possible risks to the safety of people or property. That's it. Says if that happened, then you should render a true and just verdict. Okay, so the question then becomes, let's suppose, and I'm going to give you an example. Let's suppose that you heard that somebody got arrested for reckless driving at the Woodward Dream Cruise, and the police were overcharging everyone. If you spun your tires, you got a reckless driving ticket. No one got hurt, nothing got damaged. And let's suppose that you're on that jury hearing this case. And deep down, you're asking yourself, wait a second, these people are all being charged with misdemeanors that can send them to jail and huge fines and 6 points in their license, all because they spun their tires a little bit? And let's suppose that the prosecutor puts in the case, says, yeah, the guy spun his tires. And you go back in the jury room, and all the other members of the juries go, sounds like he did it. Sounds like he did it. But you're also all thinking, but wait a second. We're all here because some guy spun his tires the Woodward Dream Cruise? That's it? So the jury could find the guy guilty if they wanted to. They could find him not guilty if they didn't think the facts rose to that level. Or quite possibly, they could also just say, something, this is a whole lot of to do about nothing, and find him not guilty. And here's the thing. There's no requirement that all of the members of the jury reach a unanimous decision on how they got to where they got. But if they take a vote and say, how many here people think he's guilty? No hands go up. How many think not guilty? All the hands go up. Go back out and render your verdict of not guilty. And is that jury nullification? Could be, if some of those people think he did it but just doesn't deserve to be charged for that. But the problem is that you're not allowed to tell the jury that. And that's the one bright line rule in all of this. You are never allowed to tell a jury, by the way, if you want to, ignore the law. So that's what will get you in trouble. But here's the funny thing. I went and looked into the federal system, because I do most of my work in the state system, but federal system's got laws and juries too. And for instance, in the federal system, I found a element and burden of proof statement that describes all the elements of a crime. And then this is a jury instruction. If you find from your consideration of all evidence that the government has proved each of these elements beyond a reasonable doubt, then you should find the defendant guilty. Do I need to be an attorney to tell you the word should is there? You should find the defendant guilty. Now again, you can't tell the jury. Should? Doesn't say must. But interestingly, I actually found a case where a judge told the jury not to nullify itself. And this one's fascinating because I'd never heard of this before, but it's a case of U.S. versus Kleinman out of California. And the court instructed the jury as follows. You cannot substitute your sense of justice, whatever that means, for your duty to follow the law, whether you agree with it or not. It is not for you to determine whether the law is just or whether the law is unjust. That cannot be your task. There is no such thing as valid jury nullification. You would violate your oath and the law if you willfully brought a verdict contrary to the law given to you in this case. And the court noted that it gave this instruction because during trial, protesters in front of the courthouse were urging the jury to disregard the law. Protesters' signs said things like, smart jurors are hung jurors, as opposed to hanged jurors. No victim of crime, and judges have the law, jury has the power. Strange thing about this, the Court of Appeals actually said, well, it was wrong of the judge to give that instruction, but it was basically harmless error. And so it's an interesting thing to suggest that a sign saying the jury has the power is wrong because it's suggesting jury nullification. I don't think so. But again, I'm not advocating for jury nullification. And remember, jury nullification is always something a jury can do. They just don't have the right to do it, for whatever that means. And that really is the question. They can go back and do anything they want, as long as it's not illegal. But if they all find that the person's not guilty, you can't question their reasoning behind it because once they've rendered their verdict, no double jeopardy, trial's over, jurors can all go home. So the only problem we have is when courts get involved and start poking around going, why did the jury acquit this person? And was it jury nullification? And can we start prosecuting people for, contempt of court? And the real answer there is, of course you can't. You start prosecuting juries, no one's going to show up for jury duty. We've got a hard enough time as it is getting people to show up for jury duty. So that's some thoughts on jury nullification. And of course, I'm not advocating for jury nullification. Questions or comments, as always, shoot them my way. Talk to you later. Bye-bye.